to make easy understand the cases I'm going to show you, I want to do a sort of promenade on the basic principles and definitions of what we are talking about. Since 1992, the European Union has a complete system of designations of origin for agricultural products, foodstuffs, wine, spirits, and other type of beverages. The legislation has been changing, adapting, and modernizing, but basically it started in 1992 as a sort of intellectual property ad hoc quality system. And of course, the mark arrived 1 year later by the first regulation creating the, at that time, community trademark, now European Union trademark. So since 93, let's say, we had these two pillars of law, which started interacting and creating some conflicts. Now we have different levels of protection at the EU level, and something I want to be very clear, this is an exhaustive system. So once a PDO, PGI is registered in the EU, member states can no longer ensure a protection, whether this is through a legislation or regulation or whatever. So it is an exhaustive system. So member states propose a designation, and once it is registered, it is at the EU level, and the member states cannot continue a protection which is only national or regional. So the highest level of protection is the PDO. PDO is defined as you see on the screen. So everything is linked with a territory. Now, PGIs is the second level. You see a very interesting concept there, which appears for wines. The term reputation, which will create some issues. And let's say that not all the conditions, not all the processes to make this product must be in this geographical place, but only some of them. So we have this different level of protection. Then we have other concepts, which are traditional specialty warranted or traditional term for wine. So you have to have in mind a series of regulations for different types of products, which are not all harmonized, which do not only speak about the same concept. So it's a quite complex body of law. You also have to know that at the moment, the Commission and the Parliament, together with the Council, are reviewing this legislation and also creating a new type of designations of origin for non-agricultural products, which I think will come in the next month, hopefully. So this is to give you an overview. Some member states are part of international conventions. You all know, I'm sure, the Lisbon Agreement. And in other international tools, we have the EU as such. So what we have is two completely different registration process. You know, we have designations of origin which come from outside the EU. The key role is the member state or the third state. There's a certain step of checking a certain number of conditions at the member state level, and then the request arrives to the Commission, which checks, of course, that everything is okay. And then there must be a publication for opposition purposes, after what it is registered. So at the moment, we have more than 3,000 PDO, PGIs registered, including those from third states. And of course, all the time there's an agreement on trade, we may have new geographical indications from third countries coming. So again, a basic reminder of what is a trademark. We have different types of trademarks that may contain a geographical element, and this is where the discussion and the conflicts will arise. Until 2017, all the signs which were capable of being represented graphically could be filed as trademarks. So designs, letters, musical sounds, packaging, videos, shapes of 3D marks, etc., with the main criteria being that these signs are capable of being distinctive. And of course, among these signs, you may have geographical indications that may be the name of a country, the name of a city, the name of a region, the name of a river, the name of a hill, a mountain, etc. So after 2017, this condition of being represented graphically was deleted from the regulation. So nowadays, we receive MP3s and JPEGs, we have little films, little melodies, and all these multimedia marks. Now, collective trademarks were, since the beginning in the regulation, in order to allow association of producers to file a trademark. And that concept was introduced in order to have these associations of producers that most of the time manage a PDO PGI to be able to protect their PDO PGI as a collective trademark. So the collective trademark, contrary to the individual marks, may contain a geographical element. So in exception to the interdiction to have a completely descriptive geographical element as a mark, collective marks may be registered for a geographical term. And last but not least, the reform of 2017 introduced the concept of certification marks, which are marks that distinguish those which are certified from those which are not certified. And of course, there we can't have the certification of a geographical origin. So if we have a certification trademark application, it can never contain a geographical element. And therefore, we refuse these applications for violating the concept of what is a certification trademark. So this is to give you a complete overview. You can come back once we finish the seminar today and think about what are the different scopes of the different type of rights when we compare PDOs, PGIs, and the three different types of marks. Now, some cases I want to tell you about. We can have, and we started having issues with certification marks in 2017-18. And of course, we have, as a result of this interaction between these PDO, PGIs legislations and the trademarks regulation, we have the possibility of refusing the application for a trademark if it evokes or its use or misuse of an already registered PDO PGI. And last but not least, if we accept the mark and we publish, owners or right owners of a PDO PGI, either as such or registered as a trademark, may come and oppose this application. So I'm going to show you some examples under these three different headings. Now, certification marks. We have, of course, I told you, we cannot accept a mark for a certification mark which has a geographical content. And here you have a fantastic example, very recent from my colleagues of the second board. The mark applied for is the certification mark for milk from Canada. So they certify a certain quality and probably the geographical origin of the milk. But of course, as I said, certification mark cannot be accepted when there is a geographical element. Or here you have two different geographical elements. You have the leaf on the cow, which is the emblem of the Canadian flag, and you have the word Canada clearly in the logo. So the mark was refused, geographical indication. In this case, you see no geographical indication. The mark arrives from the Association of Flower Exporters from Colombia. They have this sustainable certification mark. In fact, the mark was objected because the definition of what was sustainable was not clear in the regulation of use, but at the appeal level, we took note that they had modified the regulation of use and that the mark was perfectly okay. So we registered, we accepted the mark coming from a certification mark from Colombia. Now, absolute grounds, we have hundreds of cases here, so I had to choose some cases in order to show you the different nuance of our case law. In this case, the mark applied for it was Ibiza Flirt, which is very descriptive for Ibiza, and it was for alcoholic beverages. Now we have two PDO-PGIs registered in the EU. We have hierbas ibicencas, which means Ibiza, from Ibiza herbs, and we have spirit drinks with the word Ibiza. So in fact, the mark applied for went against two different PDO-PGIs. And of course, the products were similar, and therefore the mark was rejected. In the two examples I'm going to show you now, for those who speak Spanish, you may not understand why we arrived to two different solutions. The mark applied for was Fray León. Fray is a priest in the Catholic Church, and León is, well, different things, but among other things, is a region of Spain, the former kingdom, and the mark was applied for wine. Or we have two different PDO-PGIs with León for wine, Tierra de León and wine from Castilla y León. Therefore, the mark, in my opinion, was correctly rejected because it referred clearly to the main element of the PDO-PGIs, which is León. Why? Because Tierra means land, not really distinctive, and Castilla is another entity, but León is a distinctive element within Castilla-León. Now, a different solution was taken, in this case, Michel León. We had also this application for wines, but the Board of Appeal here considered that Michel León looked like, so the trademark applied for looked like a male name. There was no accent on the O. So there were some difference in the concept understanding, and therefore they considered that the mark could be accepted as such. So no two different decisions with the same León, but two different analyses on different marks. Now, in this case, we had my board, the mark comes from a Norwegian company. It is figurative, as you see. The mark was Mac Pratt, and it was applied for all sorts of poultry. Now, we have in the EU a registered PDO-PGI for pollo y capón, so a sort of chicken, of the region of El Prat, which is a region very close to Barcelona. When you land in Barcelona, the airport is on this Prat region, and this chicken is very famous, and therefore we consider that Prat in part of the mark was evoking really the Prat PDO-PGI, and therefore we rejected the mark. Now, for relative grounds, well, we have all sorts of cases, many cases with the cava, which is, you know, is a special sparkling wine coming from the northeast region of Spain, between Barcelona and Tarragona. And of course, in the mark applied for, you see two words which are really interesting. Cava, which is exactly the name of the PDO-PGI, for this sparkling wine, and vin, which is the word wine in French. So of course, I think the opposition was correctly refused. Now, this opposition was based in the Cava collective mark. So the Association of Producers of Cava, who are the owners of the PDO-PGI Cava, registered the mark, registered as a collective mark their PDO-PGI. And with that, you can oppose, for example, claiming reputation of your mark, you can oppose any other younger mark. Another example, this is a very interesting case that went up to the court in Luxembourg. The mark you see there, the roster in red with a red background, FFR means French Federation of Rugby. This is the symbol of the rugby selection and a very close symbol to French hearts. And it was, among many other things, it was applied for beverages. And of course, as you may know, the rooster is the symbol of the Chianti wine since the 18th century. And therefore, the Association of Producers of Chianti, based on an earlier registered mark, opposed the French Federation of Rugby on the similarity of the rooster for identical products, wines. And here, the Chianti Producers Association claim that their mark is reputed. And the board and the court admitted that Chianti wine and this black roaster is a symbol very well known, at least in Italy, for many centuries. So this, I had condensated a lot of cases which raise based on the PDO PGI Vinho Verde. This is a wine from North Portugal. It means literally green wine, and it is registered as a trademark in Portugal, but also as a European Union PDO. And the problem is that with their marks and the PDO PGIs they go against any mark that has verde on it. Whether, of course, it is for wines, I can understand there's possible likelihood of confusion. But when these are goods which have nothing to do with wines, it's a little bit difficult. But they have a very good budget for litigation, and they go against anything which has verde on it. Now, you know, verde in Spanish is also a color. It's green. Mm-hmm. So it's very difficult to go against the marks which have verde. Am I running out of time?
You have a little time left. Okay. I'm extending your time. This is very interesting.
So I'm going to speak about Café de Colombia and Queso Manchego, okay? This is a trademark that was applied for, among other things, coffee and cafeterias. And the owners of the PGI Café de Colombia arrived and opposed. And they oppose only on the basis of their PGI, which is accepted in the EU since 2006. And they objected and saying that there was a clear confusion between Colombiano Coffee House and Café de Colombia. And the Board of Appeal didn't see a confusion, but the Association of Colombia Coffee Producers went up to the court and won, and the mark was rejected. There are two cases. This one had the same result. So the court annulled our decision, saying, no, you have to defend, you have to protect the PGI Café de Colombia. Now we have also the same case for Pisco, which is a PGI owned by Indecopi Peru. But here the board considered there was no risk of confusion. This one is a wine coming from Chile. And in fact, we have a PGI registered in the EU, but for Región del Sur, so South region, for a particular Chilean wine. And we consider here that there was no risk of confusion. So I come to the Queso Manchego case, which we will have another example from Costa Rica. And this is a case from the Court of Justice. It's a preliminary ruling. So jurisdictions from the EU countries can ask a question when they have a litigation to the Court of Justice of the European Union in Luxembourg. And here the case was about this type of cheese where you see elements evoking Don Quixote and the Mancha region, but for cheeses which are not and do not comply with the protected designation of origin, queso manchego, which you see at the right, is the correct logo. And the Supreme Court of Spain asked the Court of Justice whether a simple figurative element without any word may evoke a PDO-PGI. And the Court of Justice said, yes, without any word, a figurative element can be create a risk of confusion and be an evocation of the PDO-PGI. So the Supreme Spanish Court recently considered that there was an infringement by these quesos manchegos, which in fact were not under the protected PDO-PGI, considered that there were infringements and annulled the trademarks and trade names Rocinantes for these cheeses. I'm available for discussion, and I thank you very much for your attention.